Hello, I'm Molly Blazek, and I wanted to personally thank you for your purchase on Guardian Connect's EDU platform. The information you're about to receive in this webinar is one of my favorites. I hope you enjoy.
This is just going to be a short webinar. I just want to talk to you, have a conversation even with you about 5 things that I wish I would have known before I became a brand new guardian. And for those of you that don't know me, my name is Molly Blazek, and I own Blazek Law Group here in Omaha, Nebraska. We are a law firm that focuses almost exclusively on guardianships and conservatorships. One of the things that makes us so unique is that in addition to representing clients who serve as guardians and conservators, I also serve as a guardian and conservator. Right now, I have about 30 folks that I'm appointed to protect or to help, and I'm very blessed to have a team of people who help me do that. So my very first tip is to not be overwhelmed. A lot of people talk about being a guardian. They talk about how time consuming it is. They talk about how difficult it is, how much court oversight and involvement there is. And I wish I would have known before I became a guardian that it wasn't as overwhelming as I thought it was. Some of you might know this story, but the only reason I became a guardian is because one day a judge called me and said, Molly, I have this case in Douglas County where the guardian has been removed. I don't know if you are familiar with the Judy Widener story, but Judy Widener was someone who served as a guardian and conservator throughout the whole state. She was also the representative payee for about 600 people. Well, that includes her guardianships and conservatorships, but she was in these positions for about 600 people across the state when she was federally indicted for stealing money from them, upwards of 6 figures. And so it left this huge void statewide for people who needed assistance and now didn't have it. There was that particular kind of case in Douglas County when this judge called me and said, Judy, the guardian, has been removed and I needed someone to become a guardian. Would you do it? And I said, well, sure. I don't know how to do it, but I am happy to do it because this is the kind of thing that, you know, you never say no to. But this judge told me, oh, it's a piece of cake, Molly. You're going to be just fine. And my joke always is that he lied. And fortunately, I was too foolish back then to understand what was required of guardians. Otherwise, I think I would have said no. But what I wish I would have done is made the distinction between difficult and time consuming. I think people make a lot of assumptions that something takes a lot of time and that means that it's difficult, and that's not necessarily true. Being a guardian, at least as far as the court's perspective is involved, is just time consuming. It's not difficult. Now, sometimes we're called upon to make very difficult decisions, and I recognize all of that. But going back, thinking about when I first became a guardian, I wish that I wouldn't have been overwhelmed. I wish I wouldn't have been scared. And so one of the missions that Blazek Law Group has is to provide a sense of comfort, a sense of ease, support to guardians and conservators across the state of Nebraska. I think that if I had had a firm like that when I first became a guardian, someone to call on, someone to rely on, someone to help me fulfill my duties, I wouldn't have been overwhelmed. And I'm here to tell you that we're here so that you don't have to be overwhelmed. One of the things that we are constantly doing is trying to innovate new supports, new resources, new services to help guardians and conservators feel more comfortable and more confident in their role and to take the edge off a little bit. And that's the thing, circling back to the very beginning, that makes our firm unique. I can lend to guardians and conservators not only the legal perspective of what's required of us, but also the practical perspective, because I've done the very same things as you. I have been called down to the courthouse because someone had a question about my accounting. An auditor wanted to know how I spent some money and why I spent it that way. I've spent hours at local financial institutions trying to get forms signed. Same with the Social Security Administration. I've spent hours there applying to become a representative payee for all of the people that I help. So I understand what you're going through from a very unique perspective, and I can help you avoid some of the pitfalls and the errors that I made early on, because I've made hundreds of mistakes and learned how to do things the very best way that I could, so that I can maximize time, reduce difficulty, and ultimately overwhelm. One of the things that I wanted to tell you guys about was when I first became a guardian. It was my second guardianship appointment ever. So the judge asked me to be appointed on this case in Douglas County. And as soon as people found out that I was potentially willing to be a guardian, the calls started flooding in. So my very second appointment is someone who I still serve as a guardian and conservator for, and I just love him so much. He was in Grand Island, and he was not thrilled about having a guardian. And I'm thankful now that he is my friend and I can consider him a friend, and we enjoy interacting with one another. But when he was losing that autonomy at the very beginning of my appointment, there were some challenges. And I recognize that a lot of you are probably not serving as guardians or conservators for strangers. It's probably a family member, or at least a friend, somebody that you're familiar with. But when I was first appointed in the second case, I was responsible for collecting all of my ward's money and putting it in a protected account. And when I did that, I had to take some cash from him, and he was not happy about that at all. And he told me that he wanted to keep the money for I'll never forget this. He said he wanted to keep it for Red Lobster and Good Living. But I took the money from him. And when he was unhappy about that, he reported it to the facility that he was living in. And they contacted the police. The police came and interviewed him for this alleged theft. And ultimately, they called Adult Protective Services. Now, this was early on. Remember, this is like 8 years ago. My second appointment ever, very little experience in guardianships and conservatorships. So I was not known at all as an attorney or somebody in this field, and the Department of Health and Human Services couldn't locate me. They didn't understand that I was an attorney and I had been appointed in this role. And the best they could do was locate my parents' home phone number, and to which they called at 6:30 in the morning and spoke to my dad. I remember my dad calling me saying, Molly, we just got this call from Adult Protective Services at home, and it was really early in the morning, and I didn't want to give them your phone number, but I got the name and the phone number of this investigator, and they want to call you back. And I was so worried. I knew that I hadn't done anything wrong, but I just was so overwhelmed. I didn't understand the process. I didn't understand why I was being investigated by Adult Protective Services. And of course, it all turned out okay. You know, I explained that I was an attorney. I invited them to come see my records, and they didn't end up investigating anything because the money that had been taken had been put directly in a conservatorship account, and I had shown that. But I tell you that so that you understand that some of the same headaches that have happened to you have happened to me, and I've made it through, and I've survived, and I've been doing this for 8 years. I've been an attorney for longer than that, but specifically guardianships and conservatorships for 8 years. And I'm still here. And now DHHS asks me to help set up guardianships sometimes. So you can see the evolution with all of this. And I'm sure that the older, well, I shouldn't say it that way, but the more experienced guardians who are on this webinar understand that it's sort of like parenting. You know, the first child, you kind of hover and maybe helicopter, and you try to buy the best diapers, and you're trying to do everything right. And then by the third or fourth, you kind of understand where it's appropriate to relax. That's what it's like being a guardian. At the very beginning, you are very regimented and wanting to follow every rule. And as you kind of go along, you realize that there are rules you absolutely have to follow. There are guidelines that are important to know. And then you have to also recognize that you're dealing with a living, breathing human being, and needs change over time. Things evolve over time. And our judges, the ones that we work with in this arena, understand that. They understand that every situation is going to be different because every vulnerable person is different and they have unique needs. So don't be overwhelmed. We are here to help you. I've got your back. Tip number 2 is something that I also wish I would have known at the very beginning of my first appointment, and that was to know your ongoing obligations. Now, for all of you who have attended this afternoon, I'm going to send out to you a PDF that has this list and then the links for the Supreme Court forms so that you can comply with this list. So don't worry that there's no PowerPoint, that you don't have to screenshot anything. Don't frantically write it down. I will send it to you. But I just want you to be aware of these ongoing requirements. I think everybody knows about the annual report requirements. That's pretty common. Guardians and conservators understand that once they've been appointed, they have to report to the court annually about the condition of their ward or their protected person. And if they manage money, they have to provide what's called an accounting. This could be a separate webinar, and I've talked on annual reports and accountings multiple times before, so I won't waste your time talking about that here. But what I want you to know are the other things that are your ongoing requirements when you become a guardian. There are 4 main ones, and there are 2 that are probably less relevant to the people who are watching, but I'll still touch on them. So the first one is anytime you are handling money for a ward and you discover that there's a new unreported asset. So think of your inventory. When you all became guardians and or conservators, you had to file an initial inventory that listed all of the assets within the guardianship and conservatorship estate. Let's say you're trucking along, one day something comes in the mail and you realize there's this bank account that has $1,000 in it and you never knew about it before, you didn't report it on the inventory. We are all required to provide the court with what's called a notice of newly discovered assets anytime we become aware of assets that are over $500 in value and weren't reported on the most recent inventory that's filed. Now remember, every year you file an inventory. So sometimes, just as a practical matter, if this is happening to me or happening to a client and it's really, really close in time to filing the annual report, sometimes we'll just do it on the updated inventory within the annual report. But let's say you're halfway through the year, you don't have an annual report due for another 6 months, and you come across this bank account that you didn't know about, or it could be anything really, an investment account, a car, there are a lot of things that become less problematic when you're familiar with the person that you're serving as guardian for. But still, there are sometimes things, policies that you're unaware of that your parents might have. Anytime you become aware of those and it's not close to a reporting period, you want to provide the notice of newly discovered assets. I'll provide you with a link to that on the PDF that we're going to send out to all of the attendees. But the important thing to remember is that once you discover that new asset, you have 30 days to report it. So that's why I say sometimes if it's close to an annual reporting period, like if I'm at 31 days, I'm probably just going to report it on my annual report. If it's months away from when I have to file an updated inventory, then I'm going to file the notice of newly discovered assets. The next one is address changes. This is by far the one that people forget about the most. If you don't remember anything else I tell you today, remember this. Anytime your ward moves, you have to notify the court of their new address. It used to be that you did that within 3 days of the move. Now they've extended that to 10 days. So now we have 10 days to report address changes. You want to report all address changes for you, for your interested persons, but the one where you get into most potential problem is not updating the court about the location of your ward. That's the one that they're probably the most interested in, because if a guardian ad litem were ever to get appointed, or God forbid you get removed and an attorney like me gets appointed, we need to be able to go to the file and see where the vulnerable adult or the minor child is immediately. And the way that you notify the court is using a Supreme Court form about an address change. So it's an address update form. I'll provide you the link for that. You have 10 days to do it. Don't forget to do it anytime an address changes, including yours, but your ward's is the main address. Now, I'll admit to you, when our wards move, which they are apt to do, sometimes we file it on the 11th day. I've never had anybody complain if I filed it on the 11th day or the 12th day, but you do want to be very intentional about keeping this particular information updated with the court. There are attorneys who have gotten in some hot water over not having correct address information for their wards. And they were doing some other things wrong too. So it's not like that in and of itself is the sole problem, but it is something to recognize and to pay attention to, and know that that is an ongoing obligation that you have. A lot of people get appointed, they get their letters, they do their annual report, but they're not really thinking about the other communications that they need to be having, one of which is address updates. The third one is a notice of death. And unfortunately, sometimes our wards do pass away and we have to notify the court of their passing. And the way that we do that is using a Supreme Court form, which is a notice of death form. This is a form that is also required to be filed within 10 days of the passing. And again, like the address changes, you know, I filed them on the 11th or 12th day. Sometimes I've intentionally held them back because I've always felt, you know, uneasy about sending that notice out, especially when a family is still grieving because the death is very new. It used to be 3 days as well. You had to send that form out within 3 days of the death, and now it's 10. But you know, no one's going to get on top of you if you file it a few days later, even if you don't wait until the 10th day. I just always try to read the audience and the situation and send out the form when it's appropriate, given the circumstances of the case that I'm working on. But you do need to send that out, and it alerts the interested persons who are involved in your case, and it also alerts the court. Now, be aware that once you do that, you're going to put the clerk on notice that a final accounting is coming. So as soon as you file that notice of death, just realize that your very next step in the case is going to be filing a final accounting if you're handling the money, or at the very least filing a motion to terminate the guardianship because of the death of the ward. One of the complications, and this is kind of a bonus, I wasn't planning on talking about it, but I just want to tell you about my experience. One of the difficult things to negotiate about these changes is that often you file the notice of death, the death certificate is not ready, but you're required to file the death certificate when you file the motion for accounting. So at least a couple of times I've had to tell the clerk, hey, I know I'm going to file a motion to terminate this, but I don't have the death certificate yet. And in the meantime, they want to issue show cause hearings saying you need to have this motion to terminate on file by such and such time. Well, in real life, we can't always get these things to line up as perfectly as we would want them. I'm sure you guys know that from trying to line up annual reporting dates. Sometimes you have to end the accounting without a bank statement, or sometimes you don't have the bank statement to end the accounting. And so you have to wait and file the report late. This is kind of an extension of that, where it would be wonderful if we could line it up perfectly, but it just doesn't work like that. So just be aware that you might be getting notices to terminate the case after you file the notice of death. And it's okay to go to a hearing and say, Your Honor, I don't have the death certificate yet. I know that the clerk wants me to file this, but I can't file it because I don't have it yet. One time, one of my wards was having an autopsy, and the death certificate wasn't issued for many, many months. And that became very complicated for us. But as long as you are in communication with the clerk and you appear at a hearing if the judge wants you to, or if you have an attorney, you communicate that with them and they communicate it with the court. It's all about communication. So just know that sometimes when you file these things, it triggers certain things with the court, and you shouldn't be afraid of that. The last ongoing obligation that is a main one I want to talk to you about is the personal and financial information form. This is something that, for those of you who filed several annual reports, remember it used to be a part of the annual report. It's the form on the very back of the packet. It's confidential. It has your ward's social security number, full name, birthday, and then it has the banking information for all open accounts. And this is the form where you're not filling out only the last four of the account, you're filling out the entire account information, the entire account number. That's why it's confidential. It's solely given to the court, and that's it. Well, now there's been an elimination of that from the annual reports. Instead, you're required to file that anytime an account number changes. So the complaint was, why should I have to be filing a personal and financial information form every single year with my annual report when I know that the social security number is not going to change and the birth date's not going to change? And so finally, the subcommittee for forms on guardianships and conservatorships recognize that really the only time you need to update this form is if you get a new bank account number. So the rules changed, the form was eliminated from the annual reports, and now you file an initial personal and financial information form when you're first appointed as a guardian or conservator. And the only other time you have to file another one is if there's a new account number. So sometimes we open and close accounts or we consolidate accounts. If we do that, we need to file this new form. Now, I'm not aware of a deadline or a time like 3 days or 10 days. You just want to do it as promptly as you possibly can. Now, sometimes, like with the notice of newly discovered assets, it's close to filing an annual report, and so I'll consolidate it and file it all together. But if your bank account number changes, you want to report that to the court. You want to do it as promptly as possible, and you can get this form like all the others I was just talking about on the Supreme Court website. I will send this to you in a PDF with easy URLs to access the Supreme Court form, and I'll send it out to all of the attendees. The last two that I want to just touch on briefly are for limited guardians and for standby guardians. So if a limited guardian becomes a full guardian or starts serving as a representative payee, you have to notify the court of that. There's a Supreme Court form for that, I think. And the purpose of that is limited guardians have limited responsibilities. And so if you are now assuming a duty that expands what you were originally appointed to do, we have to notify the court of that. Sometimes your letters will have to be reissued because of that. The other one is when a standby guardian assumes their duties. So I don't know if any of you have standby guardians in your cases, but a standby guardian is someone who's essentially next at bat. So if the guardian is unwilling or unable to serve, the standby guardian can assume their responsibilities, and you have to notify the court of that assumption within 10 days. And there is a Supreme Court form for that. Now, the standby guardian has to do a little bit more paperwork after that, but that's the initial triggering to notify the clerk that, hey, the guardian has now stepped down or for whatever reason cannot serve. I've now assumed my duties. Please issue me letters. And letters of guardianship are what is the key for all of this. And I think a lot of people get a little bit confused about that at the very beginning of a case. The guardians who are appointed in 2 steps, and this is the same thing for conservators as well. There's an order that appoints you, which is permission. You know, Molly, I'm appointing you as guardian for John Doe. That's permission for me to be John Doe's guardian. But the thing that actually gives me authority on behalf of John Doe is letters of guardianship or conservatorship. So that standby guardian wants to file that assumption paperwork in order to get letters of guardianship and conservatorship, because that's what they disseminate to the third parties to let them know that they have authority to make decisions on behalf of their individual. The third tip that I have is to keep an accounting from the very beginning. If you manage money, you need to keep an accounting from the very beginning. I have made the mistake where I didn't keep an accounting from the very beginning. And thankfully, I had all of my receipts, but it is very difficult to sit down and do an annual report and have to do 12 months of transactions when you have a lot of them and have to remember exactly what you bought and why you bought it and when you bought it. And even just transcribing it from a checkbook register, looking at the receipt into the accounting format on the annual report can be cumbersome. So my advice is don't be like me. Don't do what I did the very first time I did an annual accounting. Instead, keep that up to date as you go throughout the year. So the annual accounting on an annual report is essentially a checkbook register. That's what it is. You put the date of the transaction, what type of transaction it was, like a check or a debit or an ACH. You have to put the purpose, and that's the column that is most paid attention to, other than the amount column, by the auditors. So where you run into trouble on your annual reporting is not knowing the purpose. And honestly, that's the part of the annual accounting that is hardest to figure out if you haven't kept good records. Usually you can sort of forensically figure out using bank statements and canceled checks, the date and the amount, and obviously the person the check was paid to, or the store that the check was paid to. But the hardest part is the purpose. And you don't have to get so detailed that on the annual reporting you list everything that's on the receipt. But if I went to Walmart, for example, 6 months ago, and I spent $37 and I didn't have a receipt, I wouldn't necessarily know if that was for clothes, if that was for food, if that was something that was reimbursable to me. And sometimes you can help yourself by explaining things generically, like maybe for that example, you'd put personal items. But it is by far easier to just, when you get your bank statement every month, just write down in an accounting format what the purpose was and the information that is asked for in the annual accounting. As of a year ago, April 2020, we are now able to offer like QuickBooks reports or Quicken or Excel spreadsheets, which I always did, and I never got in trouble before this rule change. But anyway, you can now use that format instead of having to use the paper format that's provided in the annual report. So if you're getting the bank account statement anyway, and you're doing something in an Excel spreadsheet or QuickBooks, for example, and you're reconciling, it's so simple to just keep that up to date so that you're not having to do it at the very, very end when your annual report is due. My fourth tip is to actively seek out information. This was an error that I made when I first became a guardian. I sort of passively waited for information to come in the mail, and I reacted to it as it came in instead of being proactive and seeking out the information that I needed. And there are a couple of things that I can recommend that you guys do. And again, I recognize that a lot of you are not coming into situations where you're being appointed for a complete stranger, but even if this is a relative, sometimes there are things that you don't know about. And one of the very, very best ways to gather information is to do a mail forward. So whether you're doing a mail forward from a prior guardian who was appointed before you, or for the individual themselves, a mail forward is something that I do at the very beginning of any case when I'm appointed as a guardian or conservator. You would be amazed at how easy it is to just redirect the mail to where you are, and suddenly you get bank statements, and you can look at those. And the bank statements are so telling because you can figure out if there are other creditors you need to be aware of. You learn about assets, you learn about taxes. And another example of proactively seeking information is to look at tax returns. That's something that I do to try and get a big picture. And this would be good for people who are becoming the guardian or conservator of their parents. You know, sometimes we don't know everything about our parents' financial situation. We might have a general understanding, but probably not an intimate understanding. And a tax return gives us so much insight about their income sources, maybe business interests that they have, and other information that we may not be getting until the end of the year when the 1099s or the W-2s come out. So mail forward, looking at the bank records, looking at the tax returns. And then the last one is something that people don't often think about, but I really encourage them to do it. And that's an abandoned property search through the Nebraska Treasurer's Office. We do this for all of our wards, and you would be surprised at how much abandoned property the treasurer has. And sometimes it's for our wards, and you can easily make a claim online and have the whatever it is be given to you or paid over to you as guardian or conservator. So think about an abandoned property search. Even if you're not a brand new guardian, an abandoned property search is not a problematic thing to do. It's very easy. You just plug in the first name and the last name. You could do that once a year when you do your annual reporting and see if there's something out there that you haven't claimed and you don't know about. Sometimes we lose track of different assets because when we change addresses or people move into or out of facilities, or even sometimes with just different family members, if they're an aging adult, you lose track of some of these things that then get turned over to the treasurer's office. So I would really encourage you today to just plug in your loved one's name and see if there's any abandoned property. Sometimes this would be abandoned property for a deceased parent. So if we're a guardian for a minor, you might want to look at whether or not there's abandoned property from the parent's estate that the minor child would inherit potentially. My last official tip is to notify third parties. And this is kind of an extension of the last tip of actively seeking information. Another problem that I had when I first became a guardian is I shared my authority with someone when it needed to be shared, and I didn't do it just at the inception of a case. So I would really encourage you to not do it that way, because the problem is certain things happen that you might not know about or that you need to prevent. And now you're kind of late to the party because you're having to go back and say, no, wait a minute, I'm a guardian. I didn't authorize that. I didn't give permission for that. I don't want that to happen. Or you didn't make me aware of what was going on with my ward. And so when you get your letters of guardianship and you have them, you want to think about everybody that you need to share your authority with. That could be hospitals, facilities, family, friends, banks and financial institutions, creditors. Think of like utility companies, any other bills that a person would have to pay, insurance companies, annuity companies, income sources like the Social Security Administration, Veterans Affairs if they're getting VA disability, service providers like the Department of Health and Human Services. This is something I can confess to you that sometimes I'm not extraordinarily good at. I can get all this other stuff, but for some reason I just can't get the dang letters faxed over to DHHS. I don't know why that is, but often we're having to call and say, hey, I'm the guardian for this person. Could you send me their Medicaid renewal? We didn't get that. So don't be like me, be better than me. But, for a minor, this would be like schools, teachers, school counselors. Sometimes it's other professionals like attorneys, CPAs, landlords, banks that are holding a mortgage or a deed of trust, church friends, pastor, those kinds of people. If you do that on the front end, you can eliminate a lot of headaches on the back end because someone didn't know they should be contacting you when they should have about certain things that are going on in your ward's life. Now, a lot of this can kind of be obvious depending on the circumstances of your ward from the very beginning of a case. If I'm working with a facility, the first thing they're going to ask me is, can you give me your letters? But you don't often think about everybody who might need to know this information. And if you get a form letter and you circulate it to everybody, it really, really can prevent some headaches later. Now, I'm not saying that everybody will pay attention to your letter. People often don't pay attention to my letters. Sometimes we have to update Cox 4 or 5 times before they'll accept my letters and start sending us the bill. After a while, you kind of are like, well, if you don't want to get paid, then I guess don't update the records. But you want to make sure that you think intelligently about who needs this information. And I actually, another story that I have about somebody not paying attention to the information regardless is a facility who took my word to a doctor, and the doctor knew I was the guardian but made a referral for heart surgery. And somehow in that transaction, nobody notified the surgeon or the hospital that my ward had a guardian. Heart surgery was scheduled, and I found out about it accidentally the day before the surgery was supposed to happen when the facility called me and wanted to know how transportation was going to occur, if I was going to take my ward to the hospital or not. And we had no idea that that was even in motion. And unfortunately, the primary care physician who knew about my appointment really should have been the one to communicate this and didn't. But that facility knew that I was the guardian as well. And so we want to be really thinking about all of the people in a chain of command who needs to know who's, supposed to be reaching out to you or asking you for permission for things. And luckily in my situation, we just canceled the surgery and we talked to the doctor and we went from there. But, that's incredibly frightening that that could have happened without my knowledge. The last thing I want to tell you is kind of it's not an official tip, but it's just something that I've been thinking about a lot lately as I am living these situations with the vulnerable adults that I serve. And that is, I want to empower you to stand your ground, uh, and be an informed guardian. So many of the decisions that we're asked to make are based on emotion and having an emotional reaction. And oftentimes it's a medical reaction, or it's a medical situation that precipitates an emotional reaction. And we want to make sure that we're making decisions based on information and not emotion. And that's something that I feel I can really provide to my wards, because I'm not their family member, and I have more of an objective view about the kinds of things that I'm being asked to make for them. But recently I've seen more situations where I'm being pressured to make decisions that I don't think are appropriate for my ward. And sometimes even the fact that I'm an attorney is not a huge preventive to people trying to bully me into making a decision. Sometimes it is, but my point is simply that we are responsible for these people, and we are responsible for making decisions that are informed and not just gut reactions to pressure that we're facing from a medical provider. And if that's happening to you, I have your back. You can call me, we can talk. And one of the things that I'm working on doing is developing a community so that we can all be in that setting together, working with each other, encouraging one another, and frankly, to be available to answer questions about other situations that we may have experienced in the past, and we can lend some advice. I know that I am not alone in being a guardian. In fact, anytime I am asked to make a medical decision, I generally call my mother or my brother. My mother worked in nuclear medicine and my brother is an emergency room nurse. And so I typically get support when I'm walking through some of those decisions. And just to put some teeth on this, the example that I'm thinking of as I'm giving you this tip is a recent situation where we were asked to place a word on hospice. And the initial reaction was that we weren't going to do that until we were able to be let into the facility and see our ward and make an assessment for ourselves about whether or not that was appropriate. And we were told no. We were told that we couldn't come into the facility. It actually escalated to the point where the doctor who was recommending the hospice called me personally, which you would think is normal, but it's generally not normal. Usually you're only speaking to the facility social worker, potentially the director, the nursing director of the facility, but not the doctor. So the doctor called me directly and said, you know, why are you denying hospice? And I explained that we weren't denying hospice, but that if we were going to make that decision, we needed to be led into the facility to make that determination ourselves. And we were told that the only way we would be let into the facility is if we put her on hospice, and then our visit was deemed an end of life visit. But other than that, we weren't available to, we weren't going to be allowed to come in. And what was so alarming about the discussion, which is what I commonly experience in these end of life discussions, is that there's just this urgency, this pressure, this, you know, you're making the wrong decision and this person is suffering and you're not doing anything about it. And I don't know why that's often the framework that these discussions are had in. But when somebody approaches me that way, now that I've been through dozens of these conversations, my immediate reaction is to pause. And anyway, to get to the punchline of the story, the real thing that was going on with our ward is that she had a rib fracture. And they didn't want to do an x-ray on her. And we said, well, let's do an x-ray on her, because ultimately we were let into the facility. And they treated the rib fracture, and now she doesn't qualify for hospice. She's doing wonderfully. And had we wavered under that pressure, the outcome could have been extraordinarily different. So I want you to know that you're not the only one who's having difficult conversations and sometimes going against the grain. And I'm here for you. I want to empower you. I want to continue to deliver exceptional resources and support to you. So watch for things that are happening. I'm really excited about September. We're going to be launching some new things that are going to be available online to guardians and conservators as resources and as support. And these situations that I'm having are really what gives birth to the new things that we're going to be implementing. And I think that they can really help all of us in this quest to do our absolute best for those that we serve. So with that, that is my last tip. And I must have done an extraordinary job because no one has asked a single question. I do have one question that was submitted in advance. If you have questions, please, please, please put them in the Q&A and I'll get to them. But the question that I was asked was, what's the difference between a guardianship and a conservatorship, and how do the two work together? This is a very good question. People ask this often, and really the simplest way to explain it is that a guardian takes care of the person and a conservator takes care of the money and the assets. Now, don't panic if you don't have a conservatorship in your case, because a lot of these cases really only require a guardian. And that's because the law says that a guardian can do what a conservator does if there's no conservator appointed. We generally only start recommending a conservator when we see income sources beyond government benefits, or if somebody owns real property. So if you're in a situation where you are the guardian of a minor and they have no income, it's atypical to have a conservatorship involved as well. If you are a guardian and your ward only receives Social Security benefits and is on Medicaid, it's atypical to have a conservatorship. It's okay if you do, it doesn't detract from anything that the guardian is doing, but oftentimes it's unnecessary until you reach an upper echelon of things, like having those advanced income sources or owning real property, you know, like title companies and the Register of Deeds wants a conservatorship for real estate. The second part of the question is, what are the advantages and disadvantages of having the two be held, but the two appointments be held by separate people? And that's a really good question too. I thought about that before I answered it this afternoon. And one of the main advantages from a legal perspective, an attorney's perspective, is when we have disputes, and let's say there are multiple siblings who have thrown their hat in the ring to be mom's guardian, sometimes we can mitigate those disputes by giving two adverse parties individual roles. So we can appoint one as the guardian and one as the conservator. And the way that this provides relief to the family is now there's no fighting anymore. There's oversight over each other. There's judicial oversight in both of the roles and their individualized roles. And it's a really good way of solving disputes within a family. If there's not a dispute within a family, sometimes it's just a matter of oversight, wanting to make sure that separate people have oversight over these two divisions, the person and the money. The problem with having people be in those separate roles is communication and the responsibilities of each. So if there are disputes and you can't solve them amongst one another, you're going to be back in court, and that's not going to make the judge very happy about having to resolve those disputes. The other problem is third parties, like banks, for example, sometimes want concurrent signatures. So if you're the conservator and under the law, you're the one who's charged with dealing with bank accounts, sometimes the financial institution doesn't interpret your appointment that way. And they will also want the signature of the guardian. So in reality, sometimes separating them doesn't do any good, because you're going to have to work in tandem to accomplish something anyway. And for people who are like out of state, and the guardian is out of state or the conservator is out of state, but the other person's in state, that can lend itself to be a real problem. So that's one of the disadvantages that I have seen when I have dual roles like that. And then it is just in the communication. If you're not on the same page, disputes can arise, and that, you know, doesn't create a very good situation for the family. having to go to court and seek, potentially judicial intervention if it can't be resolved. And ultimately the person that you're hurting is the vulnerable person subject to the guardianship and conservatorship. And we want to avoid that to the extent we can. And I hope that that's not any of your situations. I'm sure you come from lovely families and don't fight about anything. That's my wish for you. But unfortunately, the types of cases that I tend to see are not like that. So we have to think about and anticipate potential problems. It's always cheaper and easier to prevent a fire than it is to put out a fire. Just remember that. Oh, I see another question in the Q&A. What would be the benefit of a limited guardian rather than a full guardianship? Like not having financial responsibilities for a person who's obviously not capable of handling those responsibilities. Would doing that but being representative payee work? Well, let me break this down just a little bit. So a limited guardianship in the state of Nebraska is any type of guardianship that doesn't give all 9 powers to a guardian. So Nebraska law gives 9 distinct powers to a guardian. I cannot reiterate all of them, but it's like choosing where you live, making medical decisions, entering into contracts if a conservator hasn't been appointed. But there's 9 areas, specifically 9 of them. Anything less than all 9 is considered to be a limited guardianship. Sometimes limited guardianships are very appropriate. The problem that I have found as a practical matter is that the way that the law is written is kind of archaic, and the 9 areas overlap with one another. So if I have a limited guardian who can choose a place of abode but can't sign a contract, I haven't really given that guardian the authority to select and enter into a residential agreement or a purchase agreement to buy real estate. And so limited guardianships in theory are a wonderful, wonderful thing. I've just found that they're somewhat complicated because the 9 areas under the law that a guardian is given, they're somewhat interdependent on one another. So you have to really think about what you need the guardian to do and make sure that you're only limiting it for things that absolutely don't touch any of the powers that they need. And the problem for me is that most of them are not separable from one another. The other problem is because I'm a huge fan of limited guardianships. I'm a guardian who believes that you should provide as much autonomy and independence as you possibly can. The appointment of a guardian and conservator is a deprivation of constitutional rights. That's what it is. And so I don't think we should have that deprivation in areas where it's not needed. But sometimes limited guardians are not given the same priority as full guardians. So for example, someone who is receiving Social Security benefits, if part of the limited guardianship would be to manage those funds and apply to be representative payee, there's no priority for that person to serve in that role the same way that a guardian is. The Social Security Administration would still have to go through an investigation and determine whether the limited guardian was the appropriate representative payee for the individual receiving the benefits. So it's possible sometimes, depending on what the goals and objectives are and what assistance somebody needs, but it's kind of sad really, because I think that we have so many right hands not talking to the left hands that limited guardianships become problematic even when they are well-intentioned. Something that I've come across recently and had to correct in even some of my own cases is for people who maybe have a provider or a facility serving as representative payee, in order to try to cut down on their annual reporting requirements, we've made them a guardian who has no authority over the assets of the ward. And it was never our intention that that would prevent that guardian from opening an Enable account, but that's exactly what has happened. Enable won't let them open a checking or savings account. I guess you can't open a checking account anyway, and that's an entirely different webinar, but you can't open an Enable account if you have that limitation. And so we've had to revoke some of that, lift those restrictions so that we can get an Enable account opened for a ward. And so sometimes having these limitations and these modifications really overcomplicate something that that was meant to be a limited thing to begin with. I see another question in the chat. My husband and I are co-guardians for our disabled son. How difficult would it be to set up an alternate guardian in case something were to happen for both of us? Well, very easy. That would be a standby guardian. Standby guardians are very straightforward to appoint. You go through the normal process of filing a petition, asking the court to appoint a standby guardian. They get approved. So remember when I was talking about how a guardianship appointment happens in 2 steps, you get permission and then you get authority. Well, in the case of a standby guardian, you get the permission, but you don't carry over to the next step. And so you wait to complete that until the initial guardian or the guardian, at least before them, can't serve or is unwilling to serve. But it's generally very straightforward to do. There is a flow chart on the Supreme Court website, if you guys are familiar with that, that shows the appointment steps for a standby guardian. And that can be very helpful to look at so you can visually see what steps are involved with that.
Thank you again for your download. Each purchase you make on Guardian Connect enables us to provide more resources and more education for caregivers just like you. On behalf of the entire Guardian Connect team, thank you.